The Establishment Clause of the First Amendment of the U.S. Constitution prohibits the government from establishing an official religion, taking any action that shows preference to one religion over another, and taking any action that shows preference to non-religion over religion, or vice versa. The Exercise Clause of the First Amendment gives U.S. citizens the right to practice any religion and express their beliefs in that religion.
Cantwell v. Connecticut was a court case that involved a few Jehovah's Witnesses that advocated their religion in a predominantly Catholic neighborhood. The Cantwells gave out religious materials and preached anti-Roman Catholic messages on a record player. Pedestrians reacted badly, and the Cantwells were arrested for violating a local law that required a permit for solicitation and a breach of peace. The question was if the breach of peace ordinance violated the Cantwells' First Amendment free speech or free exercise rights. There was a unanimous decision that although the message was offensive to many, it did not entail a threat of bodily harm and was protected religious speech. The case incorporated the First Amendment's Free Exercise Clause and applied to the states and protected free exercise of religion from intrusive state action. Everson v. Board of Education was a court case where a New Jersey law allowed reimbursements of money to parents who sent their children to school on buses operated by the public transportation system. Children who attended Catholic schools also qualified for this subsidy. The core question was if the New Jersey statute violated the First Amendment because people wondered if it was fair for the government to pay back parents if sending their children on buses cost money. The court answer was no. A divided court held that the law did not violate the Constitution. Justices argued that services like busing, police, and fire protection for parochial schools are separate and so indisputably marked off from the religious function that for the state to provide them would not violate the First Amendment.
The case of Torcaso v. Watkins was decided in 1961 by the Warren Court. Ray Torcaso sued for his commission as the notary public in Maryland after it was denied to him because he refused to say that he believed in God. This case was brought to the Supreme Court, who had to decide whether a state requirement that a candidate for public office must express their belief in God violates the right to freedom of religion in the First Amendment. The court decided that this does, in fact, violate the Establishment Clause of the First Amendment by showing favoritism to those who believe in God. This case reaffirmed that states could not issue any religious tests or requirements for people seeking to hold public office. Engel v. Vitale was decided in 1962. In this case, the state of New York authorized a short, non-denominational prayer for students to recite at school at the beginning of each day. The Supreme Court had to decide whether the recitation of a prayer every school day violated the Establishment Clause of the First Amendment. The decision was made that the prayer did violate the clause, which prohibited the state from making any official approval of religion. This case was the first of many to use the Establishment Clause to eliminate religious activities in everyday life. Many people were not happy with this decision, since many religious practices that had been part of public ceremonies in schools were now banned.
In the court case decided in 1971, Tilden v. Richardson, the Supreme Court questioned whether the Higher Education Facilities Act of 1963 violated the religion clauses of the First Amendment. This act provided construction grants to church-sponsored higher educational institutions. The court held that, indeed, only the 20-year limitation portion of the act violated these clauses. This was the part of the act that said that after 20 years, the schools were free to use the buildings for any purpose which they choose. This ruling had a huge effect on the interpretation of establishment and free exercise clauses because it gave it a more loose interpretation. First, the principle that religiously affiliated institutions may receive government assistance for non-religious activities was set up. Second, it was found that there was no excessive entanglement since the buildings themselves were not religious. Therefore, the case expanded the limits of governmental aid to religiously affiliated colleges and universities.
The Lemon v. Kurtzman court case applied to both Pennsylvania and Rhode Island, who adopted statutes that provided for the state to pay for aspects of non-secular, non-public education. This gave funding to non-public elementary and secondary school teachers' salaries, textbooks, and instructional materials for secular subjects. The question of the case was, do statutes that provide state funding for non-public, non-secular schools violate the Establishment Clause of the First Amendment? The court's answer was yes. There was an 8-0 majority, and the court held a statute that there must be a test in order to avoid violating the Establishment Clause. The statute must have a secular legislative purpose, its effect must be one that neither promotes nor inhibits religion, and it must not include excessive government entanglement with religion. The ruling of this case created the Lemon Test to determine whether a statute violated the Establishment Clause. This test was applied in later cases, including Santa Fe Independent School District versus Doe. The case was significant because it allowed for a way to determine if schools were violating First Amendment rights.
Another case questioning the right to freedom of religion protected in the First Amendment was the Employment Division, Department of Human Resources of Oregon versus Smith, decided in 1990. In this case, 2 Native American counselors for a private drug rehabilitation organization ingested peyote, a drug that causes hallucinations, as part of a religious ceremony. The organization found out about this and fired the counselors and denied them any benefits because the drug use was considered to be work-related misconduct. The case was brought to the Supreme Court, and the question was whether a state can deny unemployment benefits to an employee who is fired for using illegal drugs as part of a religious ceremony. The Supreme Court answered yes, a state can deny unemployment benefits to employees fired for illegal drug use, even if it's for religious purposes. An individual's beliefs do not excuse him from compliance with a valid law authorized by the government. This was a more restricted view of the Establishment Clause, since the court decided that states are not required to accommodate illegal acts performed for religious purposes.
In the 1993 court case Church of Lukamu Bablu I v. City of Hialeah, the Supreme Court questioned whether the City of Hialeah's decision prohibiting animal sacrifices violated the First Amendment Free Exercise Clause. The court held that indeed the ordinances violated the First Amendment Free Exercise Clause because they were neither neutral nor generally applicable. Like in the Employment Decision v. Smith decision, the court held the precedent that laws that happen to make a religious practice difficult or even impossible are constitutional as long as they are neutral and of general applicability. So, although the church was accused of engaging in practices inconsistent with public morals, including cruelty to animals, the prohibition of ritual animal sacrifice violated the freedom of religion clauses. In the Christian Legal Society v. Martinez in 1910, the Hastings College of Law failed to recognize CLS as an official student organization because state law required all registered student organizations to allow any student to participate, become a member, or seek leadership positions regardless of their status or beliefs. However, CLS required all members to confess in writing their devotion to God. The question was whether or not the Ninth Circuit was incorrect when its ruling was in opposition to the Seventh Circuit's 2006 decision. The court voted no. The holding that the college's all-comers policy is reasonable, viewpoint neutral, and therefore does not violate the First Amendment limitations. Universities have long sought to deny recognition of groups seeking to make certain types of belief-based membership choices, but until now have not been limited by court decisions. It is of many opinions that this could potentially result in under-recognition of groups who have controversial or minority beliefs in universities.
The case Town of Greece versus Galloway was brought to the Supreme Court in 2010. In this case, the Town of Greece, New York, allowed a prayer by an invited clergy member at the beginning of town meetings. The prayers were almost always delivered by Christian clergy members, so Susan Galloway and Linda Stevens sued the town, saying that the town's practices violated the Establishment Clause of the First Amendment by showing a preference for Christianity over other religions. When the case was brought to the Supreme Court, the question became whether the inclusion of prayer at legislative sessions violated the Establishment Clause of the First Amendment even without discrimination in the selection of prayers and prayer givers. The decision was made that the inclusion of prayer at legislative sessions does not violate the Establishment Clause of the First Amendment. The Establishment Clause was not meant to prevent legislative prayer, which created the proper mood for discussion and acknowledged the role of religion in society. The decision was well liked by legislative officials since it allowed for them to continue their tradition of prayers at many meetings.